Mediation is a place for landlords and tenants to engage with the assistance of a trained third party to come to agreements to ideally keep tenants in housing. So long as a tenant is willing to participate in mediation, a landlord must participate in mediation when a tenant has not paid rent before proceeding with an eviction. This short video provides some tips for tenants to prepare for a mediation session. If an eviction is filed with court and a court orders an eviction, tenants should be aware of the consequences of eviction. Some of these consequences include public record of an eviction, which may be a basis for a future landlord to refuse to rent, landlord attorney's fees and costs, possible report to credit agencies, which will impact credit, and in a situation where Section 8 voucher is being used, loss of that voucher. Despite these consequences, there may not be anywhere for a family to go, and facing the eviction process may be the only choice to continue to have a roof over their heads. On August 3, 2021, the federal government announced a moratorium on evictions in high COVID transmission areas. In order to qualify for this protection, tenants must meet certain criteria, complete the CDC form, and give it to their landlord. In the declaration, tenants will need to declare that 1. Their annual income is less than $99,000 for a single person or $198,000 for a couple. 2. They cannot pay rent because their income went down, they were laid off from work, or had their hours cut, or they had extraordinary out-of-pocket medical expenses, which were more than 7.5% of their adjusted gross income. 3. They made attempts to pay when they could and applied for government assistance, like rent and utility assistance programs. And 4. If they are evicted, they will become homeless, have to move into a shelter, or move in with others and live in close quarters. While challenges have been mounted against this moratorium, tenants who are behind in rent and meet the criteria should complete the form. Tenants, however, should still follow through with any notices received by landlords and participate in mediation. The notice from the landlord has important information that a tenant should review and confirm for accuracy. If information is incorrect, it should be raised with the mediator, ideally with proof. In particular, tenants should pay attention to how much the landlord claim is owed. A tenant should make sure that no rent increases are included between March 4, 2020 and August 6, 2021, and that late fees are no more than 8%. If the landlord has a federally backed mortgage, no fees can be charged related to non-payment of rent from March 27, 2020 to June 24, 2020. If attorney's fees are included, they cannot be more than 25% of the amount due and must be reasonable. For example, if a tenant owes $20,000 in back rent, it is likely not reasonable for an attorney to charge $5,000 in attorney's fees unless the attorney can document and show the work that was done on the case. It is important to note that a tenant must agree to pay attorney fees in the mediation for these fees to be added. If the amount owed is incorrect, the tenant should ask the landlord for an accounting of how the calculation was established. If rent assistance was received, a tenant should make sure that that information is included on the notice. If the tenant's application for rent assistance is still being processed, prior to the mediation, the tenant should contact the rent assistance program to find out the status of the application. If the tenant has not applied, an application should be submitted immediately. In preparing for mediation, it is important that a tenant create a budget. This should include all current and future income sources and take into account any unpaid debt like past due rent or utilities, credit card debt, or a car loan. This should also look at all current expenses like utilities, rent, food, cell phone, cable, internet, subscription services, car payments, car insurance, gas, bus pass, or parking. After taking all of this into consideration, a determination should be made as to whether rent can be paid in the future or what adjustments need to be made. If help is needed, Hawaiian Community Assets provides budgeting and rental housing financial counseling that can assist with this type of planning. There may be situations in which a tenant could have a claim against the landlord for not following the law. If any of these situations have occurred, contact the Legal Aid Society of Hawaii. These situations include raising the rent between March 4, 2020 and August 6, 2021. Under the Governor's Emergency Proclamation, landlords could not raise the rent unless the tenant had agreed before March 4, 2020. Charging more than 8% for late fees. Under Hawaii law, landlords cannot charge more than 8% for late fees. If an amount of more than this is on the lease, it is a possible violation of the law. Charging 1.5 times more in rent for any time that the tenant stayed beyond the lease or holdover rent. This was prohibited under the Governor's Emergency Proclamation. Locking the tenant out of the unit or turning off utilities. If either of these occurred, the tenant may have a monetary claim against the landlord. Discriminating against the tenant based on the tenant's race, national origin, gender, family members, marital status, or gender identity. If there was discrimination, there may be a monetary claim against the landlord that could offset back rent. However, a discrimination claim may not stop an eviction from occurring. Refusing to assist the tenant to receive rent assistance or accept rent assistance. Ultimately, the goal of mediation is for the landlord and tenant to come up with an agreement that both can agree upon. Before the mediation, a tenant should identify what the best outcome would be for them, as well as what outcome they can live with. They should also decide when it may not be worth agreeing, depending on what future housing opportunities are available to them. Some possible settlement options for tenants to consider include: if a tenant will be able to pay future rent because of returning to their job, the landlord agrees to work with the tenant to get back rent paid by the rent assistance program and keep the tenant in the unit. If rent assistance is available and not received yet, the landlord and tenant work together to get rent assistance. If a tenant knows that they will not be able to afford future rent, the tenant asks the landlord to provide them time to seek rent assistance to pay the current landlord back rent and also get some prospective rent so that the tenant can find a new place to rent. A tenant should also decide what amount they might be willing to accept if a landlord were to offer a waiver of back rent and funds for an immediate move-out. Finally, it is important for tenants to know that attorney's fees can only be awarded if agreed upon. Once you've prepared for mediation, go to the mediation program's website or review any information that they have sent to know what to expect in mediation. If a settlement is made, the mediator will write up an agreement for the parties to sign, which will also include what happens if the parties do not follow through with what was agreed to. If there is no agreement, it is likely that the landlord will file for eviction in court if they had not done so already. The tenant will need to go or appear over Zoom at the court hearing date and tell the judge whether they agree or disagree with what the landlord is saying. If they do not agree, then a trial will be scheduled. A tenant should be aware that a judge can also award attorney fees and costs to be paid by the tenant if the tenant loses. We hope this short training has helped you prepare for your mediation. More legal information resources can be found at www.legalaidhawaii.org.